Hi, my name is Sean Coppins. I'm an attorney with the Law Office of Stearns & Coppins. We're a Michigan litigation firm specializing in the practice of criminal defense work, and today I'm talking specifically about possession charges and medical marijuana cards. So there's been a lot of talk about this, and while your application for the medical marijuana card is pending, you don't necessarily have the right to possess medicinal marijuana. There is a certain period of time after which your application becomes your legal right to carry that marijuana, but it's also important to note that there are certain exclusions and exceptions to the use of medical marijuana. You still can't use it in a public place. You still shouldn't have it in a vehicle, especially if there's other people in the vehicle with you. There'll be questions of fact as to whose marijuana that is and who possessed it and who had a right to possess it. Also, having a medical marijuana card does not prevent them from charging you with possession of marijuana. Again, it does not prevent the criminal charges themselves. It's an affirmative defense to the charge of possession. So once you're charged, then we have the affirmative responsibility of showing that you had the legal right to possess the marijuana in that particular instance. Also important to note that the amount of substance you can have containing THC would include anything that marijuana is mixed with, such as marijuana brownies or marijuana cookies, marijuana lollipops. We've had a lot of cases where people were over the permissible weight because they weigh the entire amount of product that you have that contains THC, whether it's a pan of brownies or a bag of cookies. They're going to weigh that whole thing. They're not going to determine the marijuana content of it, and that's very important not to make this mistake when you're possessing marijuana products legally pursuant to the Medical Marijuana Act that we've enacted here in the state of Michigan. With other drugs, prescription drugs, heroin, cocaine, there are some things that we can look at to try to protect your rights in those cases as well. We find all too often that the police departments don't respect your Fourth Amendment right against unlawful search and seizure. We'll make sure that they did in your case. Also, we'll make sure that the possession is attributable to you in the case. Again, where we have multiple people in an automobile, multiple people in a home, there's questions of fact as to who actually possessed the narcotics that the police officers are trying to say were in your possession. Now, if they're found on your person, it can be a little bit more difficult case, but we find all too often that it's not found on somebody's person, it's found in their vehicle or in their home, and whether or not they knew it, there is an important consideration when we're determining whether or not somebody actually possessed something. So if you've been charged with a drug offense of any kind, it's important that you have an experienced criminal defense attorney handling your case. Anybody can stand next to you while you plead guilty on the nose. That's not what we do. We have various ways of protecting your rights in these serious cases. You need our experience. You need Stearns & Coppins on your side. You can reach at 586-751-0700 or 800-452-1761. Thank you.